Hello friends. Today we're going to discuss about rights of persons with mental illness under Mental Health Care Act of 2017. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about the rights which have been enumerated under Mental Health Care Act of 2017. I'll be doing this in the background of World Mental Health Day Celebration 2023, and also I'll be critiquing about the Rights-Based Mental Health Care Act of 2017 from the perspective of India. Every year on October 10th, we do observe World Mental Health Day. This year theme is Our Minds, Our Rights. Mental health is a universal human rights. We observe 10th of October as a World Mental Health Day to raise awareness among the policymakers, public at large, politicians, so that the stigma and discrimination with regard to persons with mental illness is decreased, and also the investing in mental health increases over a period of time. This year theme, hence Our Minds, Our Rights. This calls for a improved action with regard to knowledge, making awareness, and also promoting and protecting the universal human rights with regard to mental health. And these human rights are exercised against the state. Mental health is a basic human rights for all people. Every citizen has a right to the highest attainable standards of mental health. This includes right to available, accessible, acceptable, and good quality of mental health care. Now let's discuss what is mental health legislation and how in India it has been evolving. If you look at the Indian mental health laws in Indian Lunacy Act of 1912, it was basically a custodial care of persons with mental illness. Later it got evolved into Mental Health Care Act of 1987. Here, the focus was treatment of persons with mental illness. And finally, we have Mental Health Care Act of 2017. It focuses on protection of human rights of persons with mental illness during treatment, and also providing mental health care treatment as a right has been clearly enumerated. That means mental health laws are evolving, and there has been a paradigm shift from custodial care to treatment, and finally rights-based treatment approach. Now the question comes is, why should we have Mental Health Care Act? If you look at the Constitution of India, Article 21 talks about right to life and liberty. This article clearly says, no person shall be deprived of his life or personal liberty except according to the procedure established by the law. What does it mean? Every citizen and non-citizen of India have a right to life and liberty. But however, you can curtail their life or liberty by having a procedural law which has to be implemented. Now, in case of persons with mental illness, you want to curtail their liberty, like you would like to try to admit them, treat them against their wish and will. In such a scenario, you are trying to curtail their liberty. Then, to do that, you need to have a procedural law. That means it is very clear. If you want to treat a person with mental illness against their wish and will, you need to have Mental Health Care Act. And that is the reason on 7th April 2017, the Government of India came up with a landmark legislation, that is Mental Health Care Act of 2017. What does the preamble of this legislation say? There are two important preamble objectives. The first one, this legislation provides for mental health care and services for persons with mental illness. That means the government has taken the responsibility, also can called as an obligation, to provide mental health care services for persons with mental illness. That is the first obligation. The second one is to protect, promote, and fulfill the rights of persons with mental illness during the provision of services. That means it's very clear. It not only provides mental health care, but also protects and promotes the human rights during the provision of mental health services. It has 126 sections and 16 chapters, and it has been very beautifully defined various terms under the Mental Health Care Act of 2017. But however, the heart and soul of the legislation is, which is rights of the persons with mental illness. This is the first legislation in the world where the rights of persons with mental illness have been clearly articulated and listed out. If you look at the Mental Health Care Act 2017, Chapter 2, 3, 4, and 5 clearly enlists the rights of persons with mental illness. Chapter 2, that is Section 3 and 4, talks about capacity to consent for admission and treatment procedures. Chapter 3 talks about advanced directives, that is Section 5 to 13. Chapter 4 is from Section 14 to 17 with regard to nominated representatives. And finally, the rights of persons with mental illness. The rights are listed from Section 18 to 28, that is Chapter 5, my dear friends. Let's look into the capacity, that is Section 3 to Section 4, my dear friends. And later I'll be discussing other Chapter 3, Chapter 4, and Chapter 5. Now let's discuss about capacity to consent under Section 4. Here, the capacity to consent, Section 4 is very clearly, it says that every person, including persons with mental illness, has capacity. That is, by default, it is deemed to have capacity. If any person would like to challenge the person with mental illness does not have capacity, need to prove these important points. That means it does not understand the information relevant to the treatment, admission, or assistance. That means is unable to comprehend the information. The second important point is appreciation any reasonable foreseeable consequences of a decision on the treatment or lack of decision of treatment or admission or assistance. That means is unable to weigh the risk with regard to treatment or admission. And finally, communicating. Unfortunately, in the legislation, it has mentioned A or B or C, but it should have been and. Invariably, if you read, if the person with mental illness does not have all of the three, that means he does not have capacity to consent, my dear friends. Further, if you move to the Chapter 3, that is regarding Advanced Directive Section 5 to 13. Here, it clearly says every person who is not a minor shall have a right to make advanced directives in writing. Advanced directive is nothing but a living will. Here, any person can write a will how he should be treated when he develops mental illness, or how he should not be treated when he develops mental illness. Further, he can also nominate any person of his choice as a proxy decision maker when the person with mental illness loses his capacity. Now moving to nominated representative, that is Section 14 to 17, Chapter 4. Here, every person who is not a minor and a competent shall have a right to appoint any person as a nominated representative, and that person accepts the responsibility to provide care and support when the person with mental illness loses his capacity. If there is no NR available or it is not nominated by the person with mental illness, first a relative will be considered, a caregiver, or a suitable person appointed by the concerned mental health review board, or the director of the Department of Social Welfare will be considered as a nominated representatives. Now moving to the Chapter 5, that is Section 18 to 28 lists the rights of persons with mental illness. What are those rights? Let's list them. Section 18 talks about right to access for mental health care. Section 19 talks about right to community living. Section 20 talks about right to protection from cruel, inhuman, and degrading treatment. Section 21 talks about right to equality and non-discrimination. Section 22 talks about right to information. 23 talks about right to confidentiality. 24 talks about restriction on release of information in respect to mental illness. Section 25 talks about right to access for medical records. 26 talks about right to personal contact and communication. 27 talks about right to legal aid. And 28 talks about right to make complaints about the deficiency in provision of services. Here, these important rights also includes advance directives and nominated representative. That means the rights have been given to a person before he becomes ill. He can make a future will or a valid will if he develops illness. That is advance directives and nominated representatives. Now let's look into each one of these rights. What is the section 18? Right to access for mental health care. Every person shall have a right to access for mental health care and treatment from mental health services run or funded by the appropriate government. Please remember the word which is clearly mentioned. Every person. That means it need not be just a person with mental illness. Here every person includes citizen and a non-citizen also, my dear friends. So, here it is not just for the person who is mental illness. Here it is also for every person can access those mental health services which are run or funded by government. What does it mean? The right to access mental health care and treatment shall mean provision of mental health services which are at affordable cost, of good quality, available in sufficient quantity, accessible geographically, without discrimination, acceptable to person with mental illness and their family members and caregivers. What are those ranges of services which have to be given under this section 18? It clearly says from community mental health services centers upwards, these important services have to be given. Outpatient and inpatient services, halfway home, sheltered accommodation and supported accommodation, mental health services to support family of persons with mental illness, home, hospital and community-based rehabilitation, and finally, child and geriatric mental health services. These services need to be provided under Section 18, and it is the responsibility of every state to provide these services for every person in their locality or geographic location. Further, it also says mental health services should be integrated with the general health care services so that the people should not be stigmatized going to mental hospital. If the same services are provided in the general hospitals, such as district hospital, primary health care center, community health centers, medical colleges, then the person can approach these hospitals without any stigma and discrimination. Minimum mental health services should be available at each district level. And if such minimum services are not provided, such district or such state needs to provide compensation for whatever the expenditure with which they have borne to the person with mental illness and their family member for not providing a right to access for mental health care. Not only that, it clearly says that free treatment for below poverty line people, destitutes and homeless people. Many a time, persons with mental illness are wandering at large and they are homeless. They may not have any Aadhaar card, identity card or any card which can they show telling that they are poor and homeless. Hence, this law has accommodated that and clearly said if a person is a destitute or homeless, you need not ask for BPL card. You need to treat them first and provide mental health care. Further, the mental health services shall be of equal quality when compared to general health care services. Across the world, physical health care or a general health care have been given importance, whereas mental health care remains in the backseat. And funding, human resources, and also the persons with mental illness are stigmatized and discriminated. Hence, in this law, it is very clear. The mental health care services should be of good quality and equivalent to that of general health services. Essential psychotropic medications should be made available free of cost, and it has to ensure the necessary budgetary provisions for adequacy, priority, equity, and progress equivalent to general healthcare, my dear friends. Now let's discuss about section 19, right to community living. Every person with mental illness shall have a right not to be segregated or isolated, and he has a right to live in the community so that he continue to remain in a mental health establishment for any reason. That means this law has to be followed, and as soon as he recovers, he should be allowed to live in the community. That is what is very clearly every person with mental illness have a right to live in the community and not to be separated from his family or his home or relatives or support unless he has a severe mental illness which is dangerous to himself or others. Then only you can admit them and treat them against their wish and will. The appropriate government shall provide support, including legal aid, and to facilitate exercising his rights to live in the family home and also living with the family. That means if a person is admitted to a mental hospital, patient can avail free legal aid and challenge the decision of admitting him into the hospital. That is, free legal aid should be given. And it also the government should enable treatment in a least restrictive environment. That is, community-based treatment should be made available at his doorsteps, if possible at the primary healthcare centers. And various community-based homes, group homes and community-based treatment should be made available. Moving to section 20, right to protection from cruel, inhuman and degrading treatment. As you know, the earlier asylums, mental hospitals or lunatic places which were discriminatory words were used. At the same time, the inmates were discriminated. Hence, this legislation brings in new words such as mental health establishment, discriminatory words have been removed, and important rights have been enumerated. Every person with mental illness who is residing in the mental health establishment has right to safe and hygienic environment, right to adequate sanitary conditions, right to leisure, recreation, education and religious practice, right to privacy and clothing. Here, earlier the patients in mental hospitals were given similar uniforms. Now, the patient, if he is able to bring his own clothes, he can wear whatever clothes he wants to wear. And also right not to be forced to undertake work in a mental health establishment and to receive appropriate remuneration for work when undertaken. For example, patients are made to work as a part of rehabilitation. When such work is done, they need to be given some kind of token, economy, or it can be considered as stipend. Adequate provision for preparation for living in the community to be started so that the patient is rehabilitated and sent back to the community at the earliest. Wholesome food, article for personal hygiene, in particularly women's for personal hygiene, has been clearly enlisted here. In many mental hospitals, my dear friends, there were no sanitary pads were given. Even undergarments were not given. This legislation makes mandatory for all mental health establishments, especially run by government or funded by government, have to provide these important clothings to persons with mental illness, especially for females. Earlier, persons with mental illness where tonsuring or head shaving was done. Now, no such head shaving can be done unless it has been done for a health purpose. To wear own personal clothes, if so wished, they can bring and they can wear their own clothes. To be protected from all form of physical, verbal, emotional and sexual abuse is very clearly mentioned under this section 20. Now, moving to right to equality and non-discrimination under section 21. Section 21 clearly says equality to person with physical illness in the provision of health care. That means mental health services should be in par with physical health care services. It is the obligation of the state to provide emergency facilities and emergency services for persons with mental illness, such as ambulance, casualty, emergency mental health services should be provided equal to physical illness. If you go to majority of the states or else in metropolitan cities, ambulance which are provided by the government refuse to ferry the person with mental illness. Even many places do not have emergency mental health services even in medical colleges. This legislation says you cannot do that. You have to provide psychiatric emergency services. Further, child under the age of 3 years of a woman receiving care and treatment in a mental health establishment should not be separated from the mother, and the child should remain with the mother. If the person with mental illness, being a mother who is highly aggressive or dangerous to the child, in such a scenario, the psychiatrist should make a documentation, and also why he is separating the mother and child should be clearly documented, and the decision of separation should be done and review to be done every 2 weeks. Although the person with mental illness is suffering severely, she has right to access to the child under the supervision of nurses. That means you cannot just separate the mother and the child just because the mother has mental illness. Further, it also says right to insurance, health insurance for persons with mental illness. Till this legislation, all health insurance, people used to reject mental illness and tell that we will not give you health insurance because you have mental illness. Now, this legislation has given clear mandate that every health insurance should cover mental illness. Without that, they will be given fine or punishment for not providing insurance for mental illness. Moving to section 22, right to information. As per this legislation, persons with mental illness and his nominated representative shall have right to following information: reason for admission, review procedure for admission, treatment procedure, and it should be in their language what they know. That information should be given to person with mental illness and also to his nominated representatives. Suppose in a scenario where a person with mental illness is so severely ill, he is unable to understand. In such a scenario, the information will be given only to the nominated representatives. Once the patient improves, the information has to be given to him. Moving to section 23, right to confidentiality. This legislation is very clearly said. It is the duty of the every mental health professionals, people working in the establishment, to keep the information confidential. That means no person can give information regarding a person with mental illness to any person outside the treatment team. However, there are exceptions have been clearly mentioned. That means the information can be given to the NR, that is nominated representatives, and other mental health professionals and other health professionals to enable them to provide care, that is for continuity of care. Dangerous to self or others. In such a scenario, you may have to break the confidentiality. In medical emergency, in the interest of public safety and security, and finally in judicial proceedings. Moving to section 24, right to restriction on release of information in respect to mental illness. This legislation is very clear. No photograph or any other information relating to person with mental illness undergoing treatment in a mental health establishment shall not be released to any media. If you want to release to any media, the consent of the patient or the family members have to be taken. When you take the consent, capacity assessment has to be done. The right to confidentiality of a person with mental illness shall also apply to all informations, not only stored in physical, but also in electronic and virtual space also. That means you cannot give any information to any media people, and the media people also cannot broadcast the patient's photograph, information which can be identifiable, cannot be broadcasted. Section 25, right to access medical records. Here, right to access for medical record is only for persons with mental illness. The section clearly says all persons with mental illness shall have right to access their basic medical record as may be prescribed. Please understand, if an NR is asking for a medical records, you should not give. Only person with mental illness has access to medical records, not the family members or NR. The mental health professionals in charge of the establishment and records may withhold specific information which is there in the medical record, which can harm the patient or anybody else. That can be withheld. However, that information has to be told that we have withholded certain information. You can approach Mental Health Review Board for complete disclosure. Further, those information can be withholded whenever there is a serious harm to the patient or to anybody else, then only it can be withholded. And that information can be taken by a person with mental illness approaching the Mental Health Review Board. When any information in medical records are withheld from the person with mental illness, the professional should inform them that you can approach the Mental Health Review Board, and Mental Health Review Board has all the powers to give direction to the mental health professional to release those information. Moving to section 26, right to personal contacts and communication. A person with mental illness who is residing in the mental health establishment shall have a right to refuse or receive any visitor. He can also refuse or receive and make telephone or mobile phone calls at reasonable times subject to the norms of mental health establishment. That means a person with mental illness who is admitted in a mental health hospital, here he can refuse any person who is visiting him, or he can request any person who is willing to come and meet him should be allowed. Not only that, he has a right to make phone calls, communicate with emails with reasonable restriction as per the hospital norms. He may also receive and send email to any person whom he likes. But however, there has been exception with regard to right to personal contacts and communication. If the patient refuses, still a judge, member of the medical board or the Mental Health Review Board, Central Mental Authority, State Mental Authority, MP, that is Member of Parliament, MLA, nominated representative, legal representatives, medical officer in charge of the patient, and any other person authorized by the appropriate government can meet that person, move to any part of the hospital for inspection. Moving to section 27, right to legal aid. This legislation is very clear. A person with mental illness shall be entitled for free legal aid. It will be the duty of the magistrate, police officer, person in charge of such custodial settings, medical officers, mental health establishment in charge person shall inform the person with mental illness that he has right to free legal aid, and such telephone number should be shared with him to access right to free legal aid. Moving to section 28, right to make complaints about the deficiency in provision of services. Any person with mental health illness or his nominated representatives shall have a right to complain regarding the deficiency of services, provision of care, treatment within the mental health establishment. The complaint can be given to medical officer or the mental health professional in charge of the establishment. If they are not satisfied, they can move to Mental Health Review Board. Even in spite of that, if they are not satisfied, they can either move to State Mental Authority or Central Mental Authority to redressal of their grievances. Along with this legislation also talks about certain prohibition of procedures and restriction of procedures, which have been clearly mentioned under section 96 and 97. Psychosurgery for mental illness can be done only with the consent of the patient and clearance from the Mental Health Review Board. A person with mental illness cannot be routinely restrained, especially physical restraint. Physical restraint can be used only when there is imminent threat or immediate harm to self or others, and it has to be authorized by the psychiatrist in charge, and it has to be done for the less time possible. Unmodified ECT cannot be given. That means if you are giving electroconvulsive therapy, it has to be accompanied by muscle relaxant and anesthesia. A person who is having mental illness cannot be sterilized as a part of a treatment, and it is completely prohibited. Chaining, seclusion, solitary confinement of a person with mental illness is completely prohibited. ECT, especially in minor, is prohibited, but however, it can be given with prior permission of the Mental Health Review Board. Further, Section 115 decriminalizes suicide. Section 115 clearly says that any person who attempts to suicide shall be presumed to be suffering from stress at that time and will not be punished under the Indian Penal Code 309 IPC. However, if the police is able to prove it is not because of stress, still Section 309 IPC can be used. Further, admission to mental health establishment is similar to the earlier legislation. Further, once you are admitting, you need to inform the respective mental health review board whenever you are doing supported admission as per the legislation. Further, there are certain minor shortcomings with regard to admission. But however, it is in line with the international legislation and also the principles of mental health legislation as per World Health Organization. If you look at this chart, which clearly talks about admission under the Mental Health Care Act of 2017, it talks about both supported admission and independent admission. It is basically voluntary and involuntary admission. These are sophisticated words which have been used under the legislation. Independent admission means a person who is able to take decision on his own can get admitted by himself under Section 86. Whereas minors should be admitted only with the permission of the legal guardians. Supported admission comes under Section 89 and Section 90. Here, invariably either a psychiatrist, a mental health professional is required for admission under Section 89. That means two people should examine him independently and opine that he needs admission. And similarly, Section 90 requires admission, permission, and opinion from two psychiatrists. All these admissions should be informed to the Mental Health Review Board, my dear friends. Now let's critique about this rights-based approach of Mental Health Care Act. Here, especially in India, family members are the people who are providing care for person with mental illness. They are the one who are suffering along with the patient. They are the one who are providing medications. They are the one who are taking the patients to the hospitals and also rehabilitation. Unfortunately, this legislation does not give any importance to the family members. If you look at various studies which has clearly said family members play a crucial role in the course and outcome of any major mental illness. This legislation fails to acknowledge that. And involvement of family members in essential treatment of a person with mental illness has been completely ignored. Although family burden is enormous with regard to mental illness, if a person in their family is suffering, this complete ignorance has costed many family members. Although the state says that they want to take responsibility of persons with mental illness, is it possible in India? That's the biggest question. The reason being, the resources are very few. At the same time, state may not be able to provide care for so many crores of people who are suffering from mental illness. In such a scenario, we have amazing resources of family members who are willing, who want to provide care for their family members. That should have been enabled under this legislation. You can see this diagram which clearly talks about the role played by the state and the family members in providing care for a person with mental illness. If we consider the population of India is 140 crore, 10% of them are mentally ill. That means 14 crore require support and professional help. Do we have resources to provide care for 14 crore? And also, does the state have the capability to provide care for these all 14 crore population? Invariably, the support will be 0.001% by the state. Family members are the people who are providing medications, providing basic needs, rehabilitations for approximately 10 to 14 crore persons with mental illness are taken care by them. That means we need to support, empower, and also need to provide care for a person who is supporting their family member who is mentally ill. If you look at this diagram, which talks about the person with mental illness, if he has capacity and he is refusing treatment, that means you need to wait for him to become severely ill and he loses his capacity, then only you can treat him. That is one way of understanding rights based legislation. The other way of understanding is a person with mental illness is there, his illness is slowly increasing, but he has capacity and he is refusing treatment. The mental health professionals will decide to give him treatment against his wish and will so that his illness does not become severe and he does not lose his liberty when he becomes severely ill. That means across the globe, the legislations which have been implemented are two types. Either you treat him when he becomes severely ill and loses liberty. That is one way. Other way is you treat him before he loses liberty because of his mental illness. So I would prefer to treat a person with mental illness before he becomes severely ill and loses his capacity, so that the family members and the persons with mental illness, the course and outcome becomes good by treating him. To summarize, my dear friends, right-based approach looks very attractive and also very good on paper. Especially in India, the family members are the people who are providing care. Unfortunately, the individual rights have been given more importance under this legislation. Collective rights of the family members have been completely ignored. Capacity to consent has to be reviewed. And if a person with mental illness and who had past episodes of illness and severe illness is there, in such a scenario, the decision to be treatment in spite of patient refusing treatment and family members' consent should be taken to treat him. Such a law should be brought in so that a person with mental illness will not become severely ill and loses his liberty, then only you treat him. Instead of that, the law should enable the mental health professionals to treat a person with mental illness before he loses his capacity. And please remember, rights-based approach will bring enormous documentation. Documentation comes with time, and the time has to be compensated for money. That means rights-based approach will be costly affair for persons with mental illness and family members. Though Mental Health Care Act of 2017 has taken a massive step in the right direction with the rights-based approach, but this requires right amount of commitment, right amount of will by the politicians, right amount of resources. At the same time, right amount of support should be given to family members of persons with mental illness to implement this legislation, my dear friends. To conclude, we need to implement this Mental Health Care Act of 2017, keeping the burden of the family members what they are going through. We need to support the family members in providing care for persons with mental illness. Then only the rights-based approach from the perspective of Indian society becomes a reality. And hence, my dear friends, this year, the theme, Our Minds, Our Rights, is very apt. And mental health care is a universal human rights, and we need to fight for this. And we need to ensure that all our politicians, policymakers, public at large knows about mental health, the struggle of a person with mental illness, and also the enormous family burden which is undergone and undertaken by the family members has to be kept in mind. Thank you very much for giving your valuable time. Stay safe.